Okay, well, we are 7 o'clock on the dot. Thank you so much, everyone, for attending our session today. My name is Donald Garrett. I am the president of the Virginia State Association of Parliamentarians. And this session really came about because our state government in Virginia, our General Assembly, our legislative body, is really active in the winter months. It's a part-time legislature. And so they pretty much meet January through February or March, depending on the year. And there is some interesting bills pending before the General Assembly that really impact some of the meetings that we're asked to lead as parliamentarians. And my co-presenter is Jason Morgan, PRP. He's also a certified parliamentarian teacher, and he had some personal advocacy experience with some of that legislation that we'll end up talking about today. But so just because the session had just ended and we're going to go through part of that process like a little bit, but part of what we want to do as VSAP and just what nonprofits do for the members is to sort of update them like on these things and slightly advocate for them. VSAP, we really don't have a strong advocacy presence like down in Richmond. That's something that maybe we can think about. I'm trying to add our input here and there. But nonetheless, because of the results of some of the stuff that is passing and is going through and whatnot, we need to be aware of that because if clients like reach out and whatnot, it's important that we at least have a working knowledge of it. So before I begin, do you have anything you want to say just to introduce Jason?
No, no. I do think that it is vital as parliamentarians to be aware of what's going on. This does affect your clients or your future clients. So, pay attention.
Rightio. And so, just a quick agenda. We're going to go over the legislative process in Virginia, like how a bill becomes like a law, right? And we're going to examine some of the bills and legislation that happened that were submitted and their action and their status that happened in the 2026 regular session of the General Assembly and how that impacts the work of parliamentarians. And then we're going to review the different legislation. And a couple of reminders, we are being recorded. So if you don't want your voice or sound to be in the recording, make sure you are muted. I think it's set up though, so only Jason and I's cameras are on the recording right now, so you don't have to worry about that for the recording. But if you do want your CEU credits, you do need to have your cameras on. So that's a little plug that we have there. And so yeah, this presentation has been approved by the NAP Commission on Credentialing for CEU, so please keep that camera on. And we actually have a member or two of the Commission on Credentialing joining us, so they are watching. Um, what else? If you have questions, you can type in the chat, raise your hand, blurt out honestly if you need to get our attention. We'll be taking questions throughout the presentation. We'll even stop and ask for them as well too. So why we're here. So part of being a credentialed parliamentarian in our criteria for credentialing, there are provisions that talk about needing to know how to find provisions of procedural law that govern different types of organizations. And so for professional registered parliamentarians, Section 4.2 talks about that in the areas of unions, homeowners associations, condominium and cooperative associations, and other specific types of regulated associations. You'll note that this actually pretty much mirrors how the Virginia law is set up in the different areas that we'll be looking at. And for the RPs, Section 7.14 talks about how RPs, registered parliamentarians, need to understand and identify how the procedural rules and law may apply to an organization and may supersede the organization's own rules as explained in Robert's Rules of Order. And so something to be aware of in Robert's Rules of Order, and even in the first section of the book, so section 1, paragraph 5, it says, aside from the rules of parliamentary procedure and the particular rules on assembly, actions of any deliberative body are also subject to applicable procedural rules prescribed by local, state, or national law and would be null and void if that rule or action is in violation of such law. So again, just from the very first section of Roberts, it says everything that you do as an organization, make sure it doesn't conflict with the procedural rules that are in state, local, national law. And congratulations, we're talking about state law today. So that's, one of the reasons why you need to be aware as parliamentarians. And then that even goes on to the next section, section 2, paragraph 18. The book says when a society has adopted a particular parliamentary manual, such as Roberts, as its authority, the rules contained in that manual are binding upon in all cases where they are not inconsistent with the bylaws of the body, any special rules of order, or any provisions of local, state, or national law applying to the particular type of organization. And so we see it there again, right? The bodies, your assemblies, they can adopt bylaws, they can adopt rules, but if the law supersedes what's in those rules, you have to follow what's in the law. Now, Robert's Rules of Order and the NAP criteria for credentialing, they don't require us to be attorneys or anything, right? But we have to have a working knowledge of where to find like certain things, right? And see if things are applicable. I always like whenever I talk about this sort of thing with other parliamentarians. I like to kind of refer to us like we're similar to architects, right? Where someone's like designing like a building, like they're like an engineer by trade, right? And so they understand like what the building code standards are when they're, drafting design, but they're not practicing the law that this is in the local ordinance, 2 point whatever, whatever, and advocating before a court, right? And so as parliamentarians, we have to take the same way as an architect knows what the building standards are when they're designing a building, we need to know what the meeting standards are when we're designing a meeting, right? And so, especially a lot of these things, it's really you're keeping it more at the you're pretty much giving your factual opinion, like on certain things, right? Helping groups count quorum, taking counts of different votes and whatnot, right? That's really not the practice of law, but it's mainly you're really observing again as part of like that expertise and being able to know like where to find that. So before we dive in, anything you need to add there, Jason?
Same type of thing. That look, accountants don't have to be lawyers to apply the tax law to uh, or tax laws and other laws that they're bound by. They have to be aware of them. You bring in lawyers when the law is unclear and you have to interpret it, or you're arguing it in a court of law. So yes, lay non-lawyers can and should understand enough of the law in the domains that they work in.
Right.
100%.
And 9 times out of 10, when you're working with these groups that are we talk about today, they will have their own attorneys. And so you'll just bounce your ideas and whatever, like past them, and they'll give you their thoughts on it as well, too. So it's not like a big, huge cause of concern, if that makes sense, because you can just interface or, draft the question for the chairperson to ask the attorney and get their advice on it. Okay, so how a bill becomes a law, in one slide, basically. So the laws in Virginia, they're created through our actions by our legislature and our governor, right? And so our legislative body is the General Assembly. We have a House of Delegates and a Senate. They also have various committees, right? And throughout their process, a bill has to pass both those houses of the General Assembly in the same form. Our legislative body is part-time in Virginia. Like I said earlier, they only meet in the winter months in January through February or March, depending on the year. And so the legislative session is really a time for them to kind of power through their big agendas and do lots of up or down votes. And so outside of session, they actually do have a lot of interim study committees and whatnot. And Jason will talk about that, about the FOIA Council like a little bit later. They have interim study committees that do a lot of the studying and work in between the regular sessions, right? That then come up with the legislative proposals that then get voted on in the next winter, right? And so just because something might not pass at this session, it might be percolating between sessions and brought back like the next year, that sort of thing. And so a lot happens. And so all the legislative normally happens in the winter months, but then sort of legislative drafting, stakeholder engagement, research, studies, et cetera, happens throughout the year, basically. So,
And Donald, I just want to emphasize it is an incredibly fast pace. It is breakneck. It is very difficult to lobby because things change on the fly. Uh, Donald was able to speak at one of the hearings, and I I didn't find about it until the afternoon and couldn't register to be online to speak to it because I was just too late. And it was like 5 o'clock, but 1 o'clock, I think it was noon or 1 o'clock was the deadline. So it is very difficult for non-professionals to lobby effectively. So trying to professionalize that, have some kind of ongoing monitoring, have tiger teams, something would be very useful for the parliamentary community and for our representation of our clients and our future clients. The other thing I think worth noting is some stuff does pass the year it's introduced. And we actually were able to push back. I was blamed for this. From what I hear, for causing a delay by pushing back on something which was set to pass last year. What I found is it's not the committees that you have to worry about, it's the subcommittees. You have to show up there because you may have called, you may have emailed, you may have written letters, you might have a huge campaign, you may have people protesting outside. And what you will find is that a lot of the legislators, if not most of them, really aren't paying attention until it's in front of them at the subcommittee meetings. But they do ask at those meetings, does anyone from the public want to speak? And that's your chance to say, this may be something we really support, or this is something that maybe you need to think about a little bit more. So getting in there is critical. And because there's often very little notice, it's a challenge. It's got a little bit easier because of they're more open now to online discuss, showing up online if you've registered in time, but yeah, it's still a challenge. All right, please go on, Donald.
Oh yeah, so that's a plug for that. But we're in the phase now where we're monitoring and responding, right? And so, but it's a cycle. So if VSAP, other members and whatnot are interested in some stuff we're talking about today, now is the time to kind of start that engagement with your legislatures because it's going to be January real soon once again, and that's where it's fast paced, like Jason said. After the bill passes the General Assembly, then it goes to the governor, and our governor has pretty much three options. She can sign it into law. She can veto it and send it back to the legislature, which they can override the veto with a two-thirds vote. Or we have line item veto authority in Virginia, so the governor can suggest amendments and send it back to the legislature and whatnot. And then after the executive approves it it gets overridden, then it's enacted, right? So law is actually published. And in Virginia, most laws go into effect on July 1 unless otherwise stated like in the law. And that's when the enforcement really begins. So these are the seven main areas that affect the work of parliamentarians. And so today, we're really focusing the bills that we're focusing on deal with public meetings, nonprofits, corporations, and small business. Other areas, just like in the criteria for credentialing, talked about like HOAs. They like to be called community associations, labor unions, credit unions. But the four black ones on the screen now are the areas that we'll be focusing on today and their impact on our meetings. So the first area we'll talk about is the Freedom of Information Law in Virginia, and there's a couple of bills that we tracked and we'll report on today that deals with Freedom of Information Act, or sometimes called FOIA. But before we dive into those, I want to sort of set the stage for what exactly FOIA is and what the purpose of it is. And so in the Virginia Freedom of Information Act, it mandates open government meetings, right? And so in the law, it says the policy of our legislative body is that the people of the Commonwealth should have free entry to meetings of public bodies where the business of the people is being conducted because the affairs of government are not intended to be conducted in an atmosphere of secrecy, since at all times we, the public, are the ones that are the beneficial of any action taken at any level of government, right? And so that's sort of the overall policy statement that Virginia, we have open government meetings because your taxpayer dollars fund it, and you should be able to see your taxpayer dollars at work because you're the benefit of these public meetings. And so, who is this law? Who does this act apply to? So, public bodies, and public bodies are, it's a very broad definition in Virginia. It's everything. So, on this slide, we have pretty much. This is the section of the act that has a definition, but it has pretty much everything from legislative bodies, right? And then anything that's like counties, cities, school boards, governing bodies that include city councils, right? And their planning commissions, public institutions of higher education, so board of visitors, right? And then even it includes other organizations, corporations, or agencies wholly or principally supported by public funds, right? And so even if it's like a random like community nonprofit, if their budget is substantially funded by the state tax dollars, then it could be a public body subject to FOIA, right? And so anything that you think of typically government, right? So like your city councils and your legislative bodies and your school boards and your planning commissions and whatnot, those are public bodies, but it also include private organizations that get substantial funding from the government.
I,
And
no,
also, at the end of this definition slide, it also says any committee, subcommittee, or any other entity, however designated of the public body, created to perform delegated functions or to advise the public body. So, I mean, even some school systems, they have really robust parent involvement, right? Unlike advisory committees, since that advisory committee is advising the school board, who's a public body, the advisory committee is subject to FOIA, right? And so FOIA is important because it's not only the work of our elected officials, it's also the work of the people who advise elected officials, right? They might be subject, and those meetings are open to the public, and most of them follow parliamentary procedure. So the first bill we're going to talk about is House Bill 463, and this was submitted by a delegate who represents like the Springfield, Virginia area up here in Northern Virginia, and it dealt with just the definition of what it means to be a meeting under FOIA. And we'll talk about the text in the next slide, but this is a bill that did not pass through committee or subcommittee. Instead, what they did was they continued it, right? Which means it's going to go to next session, but in the interim, it's going to be studied by the Virginia FOIA Council. And Jason can talk about a little bit more what that means because he dealt with that last year when a bill got continued to the FOIA Council. But essentially, this bill it would have changed the definition of what it means to be a meeting like under FOIA. So if you focus on the left-hand side of the slide, under the current law, a meeting under FOIA is a very, very, very broad definition, right? So it includes meetings, it includes work sessions, whether or not you are meeting electronically. It also can include informal assemblages, as many as at least three people, right? Whether or not you're taking minutes at that meeting, right? And whether or not you're taking votes at that meeting, right? So when we think from meeting in a parliamentary procedure standpoint, we normally think, okay, this is, notice, we have a chairperson, we have a secretary taking minutes, right? We have votes going on, right? But under FOIA, meetings actually even broader than that, right? So if they're just having like a stakeholder listening session, right, that could be a meeting. If they're just having what they call like a work session or an informal gathering, that could be a meeting, right? But the key here is under current law, if you have as many as three people of a public body together, that constitutes a meeting. You have to go through all the different FOIA requirements for a public meeting, right? And so if you have an advisory committee of, 20 parents on something, three of them can't get together and discuss that. They have to trigger, they would trigger the public meeting responsibilities.
yeah, John,
So
and actually, I want to emphasize electronic communications is read very broadly as well. So if you have, say, a bunch of parents on WhatsApp or elected officials on WhatsApp or Signal chatting away, that would probably be considered a meeting if there's at least three or more. Email. Now, if it's a unilateral email that goes out to everyone and there's no response, there's no dialogue, probably okay. But if it starts to look like a dialogue and that it's just trying to do what you would do in a physical meeting, but you're doing it by email, courts have interpreted that as a meeting. So it is much broader than anything you would think would reasonably be a meeting under Robert's Rules of Order newly revised. And it's very problematic. I'm just going to, Donald, do you want me to talk a little bit
Yeah,
about what the
go ahead.
current, yeah, so, it's very difficult for a body of any size, uh, more, say, 6 people or so, to kind of socialize ideas and figure out what it is they even want to talk about because they of this you get you talk with 3 people at once or 2 people at once I should say, and now you've got a meeting that has to be public and in front of everyone. You end up with these horrible workarounds where members will have one-on-one conversations with everyone.
Game of
What do
telephone.
you think? Now I'm going to talk. So, Donald, what do you think? You know, what do you think? We're going to have just a one-on-one conversation, and then, it's very difficult to communicate effectively in that kind of environment. And you will see that a lot of the legislative push is for transparency, but at the it does come at the expense of governability, of effectiveness of these bodies, because so much it gets pushed into the fishbowl rather than just be able to talk about things, ideas, just share information about ideas without triggering these statutes. So anyway,
Yeah, I mean, I think Jason hit on something that's actually really not addressed in Roberts, right? Is how do I get my idea to create my motion, right? Most of the time you would talk with our friends in the organization, right? Hey, would you support that? And you kind of get a little bit of support before you put it like on the floor. This definition makes that really, really hard, as like he was saying. And so the proposal would change the threshold to pretty much be you can have informal gatherings, but as soon as you reach it to be a quorum of the body, it needs to be a public meeting, right? So you can kind of see on the left of the slide versus the right of the slide, the right, the proposed changes, it set the threshold at a quorum. Um, and so, I thought it was a great change. The delegate during the public hearing talked about they were concerned about being able to carpool to school meetings together because they didn't want it to be like a meeting under FOIA, right? If the three of them were like carpooling together. So it was little things like that. But the committee, they didn't kill it. They sent it to the FOIA council with a letter, which means they're going to study it in the interim. And that's a chance for VSAP or Jason or whomever to maybe advocate about maybe the impact of this legislation. And so that's really sort of the next steps. And I think what we actually might do is you might uh, be armed with some facts, right? Because I mean, I think if I had to guess, that three-person threshold was probably under the assumption that most like city councils have like 5 people on it, right? So three is like your quorum. But as we know, government has grown and gotten bigger and bigger and bigger throughout the years, and they're really big on stakeholder engagement, right? And so by keeping the meeting threshold at three, it really penalizes a lot of volunteer members, right, who are just trying to serve in these advisory bodies. And so I think there's a way to maybe show that for the important public bodies like the city councils and the school boards and whatnot, even if you go to like the word quorum, it's still essentially going to be three, right? Because it's a five-member body, right? And so I think there's a way we can maybe present that math to the FOIA council when we're going to advocate on that bill. But I think as parliamentarians, when we are asked to teach a class or educates like a public body, right? It makes our job easier just to explain that this is your quorum, right? So as long as you reach your quorum threshold, like that's when the public meeting responsibilities occur. And I think it just eases compliance, especially for the really, really large citizen centered advisory bodies.
Donald,
Hmm.
just as a practice note, if you are supporting a public body in Virginia, don't make their lives more difficult. If you're going to reach out to two members.
Yes.
Don't be the one who starts dragging them into, because if they accidentally reply and then now it's three members who are talking with each other, you may have accidentally enticed them to violate the open meeting law. So maybe the chair, if they have a vice chair or someone else, email two, don't email three,
Yes.
not at all.
So that's the next steps. The bill's continued to next year, but there'll be some studying in the spring and summer and fall. So VSAP, we might weasel our way in there if you want to maybe have a stake in this legislation for next year. The next bill, this is the Jason bill. I'll let him present on it, but this is
No,
Senate Bill
don't say it's the Jason bill.
Senate Bill 699. This is about the short title. This seems so innocent, right? Public bodies oppose meeting agendas. And so this was introduced by Senator Adam Ebbin. He actually just resigned from the state Senate because he accepted a post in the governor's cabinet. And so this bill had passed the General Assembly, and right now it's awaiting governor's action. So she has until January 13th. I'm sorry, April 13th to either sign, amend, or veto. And I will let Jason speak about the particulars of this bill.
Sure. Well, first of all, it passed unanimously in the Senate. It passed with very few opposed in the House. It is very unlikely that there's going to be a veto. Maybe some tweaks if it, but I doubt it. I'm very skeptical that you're going to see any real tweaks to this. This relates to whether a final action can be taken on an item at the meeting, at your meeting. And it can, but only in two cases. One, it was on an agenda that was published before the meeting started, or two, it's time sensitive, whatever that means. This creates a few challenges. I think you've got some in on the other slides, but that's the basics of what the statute does. They did after last year. That was basically all it was, and it wasn't clear. At least it wasn't clear to me what the enforcement mechanisms were. I offered some language like, well, if anyone objects to it, then maybe it requires a 2/3 vote to say that it's timely. Didn't get accepted. Got sent to the VFOIA committee, council, excuse me, VFOIA council, who they bounced things around. I was down there, I think once or twice. I talked to them twice. I was down there once, and they came up with some exceptions that got it through the VFOIA Council. That was what was recommended to the Virginia General Assembly and what Evans eventually submitted and what's been adopted. So the exceptions are, well, if you're just referring to a committee or advisory body, that's okay. If you're referring to the future, if you're doing a postpone to a future meeting, okay, that's not a final action, which to me, I don't think you really needed that one. Direction to staff to provide further information. Not doing anything, just asking the staff. It's okay to ask staff for information. Or if it's something that really has no impact, specifically commending or memorial proclamations. A lot of times these are just, Black History Month, Pride Month, whatever. If you didn't remember to put it on the agenda, you can still bring it up during the meeting, vote on it, and it's okay. It doesn't have any substantive impact as far as causing any rights to be gained or lost. So I think they felt pretty comfortable about creating it, adding that to the carve out. But those are the carve outs. And there are some questions. Donald, do you have all the things on the next slide? Some of the
Yeah, but yeah, the main thing on this slide, you have to pretty much final if you can take final action at a meeting, it has to be on the pre-posted agenda, which is on the website.
Yeah.
And
You can't amend the agenda at the meeting to include
correct.
the item. It has to have been on there. It could have been put on there a minute before the meeting, but it
Hmm.
has to be on there. And this creates some issues unintended, well publicized. I think between Donald and or the VSAP and I brought up these issues, and they were dismissed. One is, can the agenda preparer
Just leave it off the agenda.
not put it on the agenda? This happened repeatedly in Oklahoma. There's superintendent had the responsibility of preparing the agenda and would not put items on the agenda that the members wanted to discuss repeatedly. And something like, well, I want to censor the superintendent, the agenda preparer for not putting it. Well, too bad. It's not on the agenda, so you can't take final action on it. It creates this awful quagmire if you have a agenda preparer who is willing to act in bad faith. Uh, Another unintended consequence is that bodies are likely to try and create very non-specific agendas that have items that are very broad as possible rather than specific in order to limit the risk that an item will be deemed as not having been on the agenda. The oral previous notice, I mean, this is just one of the suggestions that had been made was to allow members to put something on the agenda through oral previous notice, and that was disallowed. And the last thing that there's no enforcement mechanism within the meetings themselves. The enforcement mechanism, if someone is unhappy with an item that passed, that there was a final action on that was not on the agenda, is to take it to court. And there is a whole series of provisions. So that was my last year when I objected to this. That was my concern. I didn't understand how to support a body with the statute. I brought that concern again this summer and was told, well, no, there's all this provision. It's like, great. So you can sue to have it thrown out, to have the action vacated, even if everyone except for the person who complained supports it. Even if the members, if it had been on the agenda before, would have supported, or if there had been a motion to ratify it a week later, would have accepted that. None of that matters in this context because there's nothing in the statute that would allows for that. I mean, it gives the circuit court judges a lot of leeway to say, well, this was violated. What's the remedy? Throw it out. That happened with at least one statute or one ordinance in Fairfax County. The was in apparent. The argument was that it had been adopted through an online meeting that where it wasn't really an emergency that required an online meeting, and they ended up having to, after a lot of work, vote on it again after it had gone through the court system. And there's one other thing I think that goes back to the non-specific agendas. Stuff happens at meetings. I have seen it. Especially when the only possible communications beforehand were a lot of these one-on-ones, these games of telephone. Something that it is difficult going into these meetings to have something that's finalized without any of that kind of that discussion ahead of time, that kind of caucusing. So an amendment a compromise amendment could potentially render an item as subject to this statute where the body cannot actually take final action on it unless it's deemed time sensitive. And again, time sensitive, that's a lawyer question. I would say the body, if that comes up, should make a finding, but it may still be subject to legal action and possibly having that decision second guessed by a judge.
Yeah, and so just, we as parliamentarians, we're taught to find our solutions for our clients, right? And just like Jason said, some of these things like oral previous notice, like remember under Roberts, we can, make motions for reconsideration, right? And call it up later, or say, I want to offer a motion to repeal a previous action and things like that, right? But those might not be applicable if they don't make it to the agenda.
So we have some ideas, things that you may need to talk about with your clients if you have public body clients. Uh, One is if something's being introduced, say under new business, to go ahead and have the discussion, but postpone it, refer it to the next meeting. This can be a little bit problematic. There are some bodies, I've served on bodies as a volunteer member where all the decisions get made at the last meeting. So, and where all the compromises. So that creates well, what are we supposed to do if we haven't figured out until that last meeting what it is we want to actually decide? Well, maybe you have to have another meeting afterwards, or potentially delegate to a a subordinate body, similar to how you can delegate approval of the minutes. You may need to have some kind of action taken, something similar to, in the charter for the committee, saying that yes, you can delegate to a subordinate committee uh, the ability to make technical and conforming changes and take final action on something that was agreed to. You may need to do some kind of workarounds in order to allow for some of these bodies that will terminate to make decisions at the last minute that can take effect. Or at least make a finding, have a vote. We consider this to be a time-sensitive matter. There's some other things. Adopting rules for agenda setting is I think most bodies really should have something for that anyway, because it is so unclear for a lot of bodies that they're not introducing items in new business where it's just members being called on. Typically, there's a lot of queuing up and scheduling when something should happen and putting some clarity so that the members themselves have that ability is useful. So
I mean, and
like
especially I would even recommend that for the public bodies that a staff person do it right because they're gonna get paid to do their job, right? And not have the volunteer chair or whomever because sometimes there's a little bit of personality conflicts that get in the way of just the ministerial duty of putting an item on the agenda.
and and I don't know, Donald, what you think about this, but maybe even having before your regular meeting, have a committee of have a committee that sets the agenda. And it could just be the whole body meets, prepares the agenda. That's the only thing, is prepare the agenda for the regular meeting, closes out, and then the new meeting begins. It's an option. Although, whether that will pass muster if something's challenged, that's a question for the courts to decide.
Yes, so we have a question in the chat. Could they allow for emergency actions not on the agenda and just require a super majority for adoption? So, under the current wording on the left side, let me see if I can get my little highlighter going. Um,
It's timely, time sensitive.
yes, there we go. So th there is a time-sensitive exception to this rule. What exactly time-sensitive means, like Jason said, it's not really defined. And so I think the recommendation would be either do like a motion or a resolution, whereas this is time sensitive because we just found out about this 2 minutes beforehand, be it resolved that we do X, right? So you at least have it on the record that the body agrees that it was time sensitive.
Yeah. And it would be preferable, it might help to have that finding made separately. So it
Hmm.
doesn't look like it was just kind of shoehorned in there, to have it separately. Putting in the rules so bodies can have some leeway to establish some rules for themselves. make it a rule that if it's going to be time sensitive, that it has to be by, say, a super majority vote. That way, if it does go to the court, you can say, well, look, we either considered this to be, we considered this, we voted on it as a time sensitive matter. Um, the vast majority, a super majority agreed to it. And at least it provides a little bit of gravitas in that decision that the body did think of that particular issue. I think the bigger issue for bodies is especially ones that don't have access to a full-time a lawyer who's really focused on what they're doing. And there are lots of public bodies where that's the case, where it's just not on any lawyer's radar, not any lawyer who's really that paying that much attention to this statute, uh, that they're not going to realize that they have an item that should have been on the agenda before it got voted on. So, but if you get to the point where you're actually thinking this is a time sensitive matter, let's talk about that. And then once we've decided it is time sensitive, we can vote on it. I think if you're doing it, you have that level of sensitivity to the statute, you're probably in pretty good shape.
Yeah. And the other practice point too is if you look at the left-hand side, I'm putting a highlight right here, right there at the top. Um, the only requirement is that the agenda has to be posted prior to the meeting. So the statute really doesn't give a deadline for posting it, right? And so you still might have some leeway even leading up to the meeting, as long as it's posted prior to the meeting. Now, again, what prior to the meeting means, not really defined, but it's at least some time point before it's called to order.
Yeah. And interestingly enough, you only have to post it if the public body has an official government website.
Yeah, if any.
So it's a little bit, but but it's got to be on the agenda. Even if you don't have a website, you still have to have something on the agenda before it gets voted on. At least that's one interpretation.
Yes. So, were there any other questions about FOIA before we go on to our next topic? Okay. So now we're going to talk about corporations. And so this is an area that actually is talked about in Roberts quite a bit when when they say bodies that might have laws that like apply to them, right? Corporations is always an example that the body uses. And so just the quick definition of corporation is a group of people, such as an association or a company that's authorized by the state to act as a single entity and is recognized under the law for certain purposes, right? And so a business becomes a corporation through a process called incorporation, which grants it separate legal status from its owners, right? And so that requires filing articles of incorporation with the state agency, bylaws, etc. And so once your group is incorporated, the business is a distinct legal entity with the power to own property, enter contracts, be sued, all separate liability from the individual owners and shareholders. And so in Virginia, the two main acts are the Virginia Stock Corporation Act and the Virginia Non-Stock Corporation Act. Parliamentarians, you normally deal with the non-stock corporations because that's what the nonprofit organizations associations typically are incorporated under. And so I have this quick little example to show you what we mean by non-stock. So a typical corporation, a stock corporation, right? When you have your revenue, right? And then you have your expenses, and then that's essentially going to make your profit, right? And so a stock corporation, once you've brought in all your money, you paid all your expenses, that profit then goes to your shareholders as dividends, right? They can authorize dividends, be like, okay, well, we have this many billions to give out, so we will issue these dividends to our different shareholders, right? That's a stock corporation. So when we hear the word non-stock corporation, instead, the corporation, they're not allowed to give out dividends. Instead, that profit just gets retained by the corporation and is just used for furthering its purposes and reinvestment in the organization itself. So that's what we mean by non-stock corporation. There's no dividends or anything, and so nonprofit organizations are prohibited from paying out dividends, and that's why pretty much all nonprofits are non-stock corporations, but not all non-stock corporations are nonprofits. That's the relationship there. But parliamentarians, we normally deal with this type of corporation. It's called a non-stock corporation in Virginia. So there were two bills, there were companion bills in the General Assembly, Delegate Hope from Arlington and Senator Scott Survell from Southeast Fairfax. There were pretty much or numerous revisions to these acts. They were there are a lot of technical amendments. It was like 79 pages worth of amendments, right? And so these both passed the General Assembly, and there's a delayed effective date until 2027. So that's really, really good news. So that gives parliamentarians, lawyers, everyone at least a year and a half to kind of mull through what some of these changes mean for their organizations. And we're going to go through I have a few changes. We're going to go through the different ones and how they might interact with and how they might conflict with what we do based off of Roberts or incorporate what we do off of Roberts. So first, the first change that we're going to go over, the law now has a section in there about ratifying defective corporate action. That was Roberts. Well, Robert's Rules of Order does have sections in there about the motion to ratify, but now this is a right that corporations have um, just by law, by right. And so that's really important because it allows the board and or members, if they refer it to members, to ratify any sort of defective action. And so that's things like if action was taken without like a quorum, or they didn't get the appropriate vote, then they redo the vote and things like that, right? Or the meeting was not called, the meeting was not properly noticed, right? They can pass a resolution stating the defects and that they're ratifying it to then be correct.
Yeah, and Donald and I got a chance to to work with ratification in a very public manner several years ago, um, with an organization where the board of directors had made some decisions that the bylaws really said belonged to the members, and they were acting on it. The members ultimately ratified those at an annual meeting, but we followed Roberts. It is worth noting that this is the statute, if I read it correctly, um, it provides a default. Here is how you can ratify.
Yes.
So if you have a body, say if you're representing a body that didn't adopt any rules of order or adopted one that's really, I mean, and there's some rules of order out there that are like nice and thin, but really don't have much meat on them. If they've done something like that and you're trying to support them, this gives you a fallback that you can rely on. But if they have adopted Robert's Rules of Order newly revised, the statute says that this process is not deemed to be the exclusive means of ratifying or validating a defective corporate action. So I would say, I would interpret that as saying, if your bylaws or your adopted rules of order allow another means of ratification, you probably can use those. But of course, if you use this, it's even better because it's in the statute itself.
Yes. And so this is the quote from Roberts about ratification. Like Jason said, if you adopt Roberts, you're able to use this procedure to make valid an action that cannot become valid until approved by the Assembly. Next change, this is a fun change. So in corporate language, they call it different classes of membership, right? So where we have, well, even here at NAP, right, we have our different classes of members, right? Or some organizations, they might have associate members and secondary members and pledgees and whatnot. Now corporations are pretty much just allowed to authorize it in their bylaws, right? So the bylaws can designate different classes of membership, give them different rights, qualifications, responsibilities, limiting or denying the right to vote. Beforehand, it used to have to be provisions in their articles of incorporation, but now it's just all done in the bylaws. So that's a great change that because you don't have to go searching for what was in the original articles to see if they have to update those. It can all
I,
be done in the bylaws now.
yeah, I'm going to give just a few thoughts on that. Uh, the articles of incorporation are actually not that difficult. They're hosted by the State Corporation Commission. And the challenge with those is you do have to file them, and they have to be adopted. They have to be filed accepted by the State Corporation Commission. You don't necessarily have to do that with the bylaws. The bylaws also aren't necessarily going to be public. And the members, I believe, should have access to them, but non-members won't necessarily have access to them the same way that you would with the articles of incorporation, where anyone can ask to take a look at them and peruse and get a little bit of idea about some of the high level structure. Uh, if you have any members or any clients who want to make use of this provision, I would still recommend you make sure that you have a copy of their current articles of incorporation. Because if the articles of incorporation do in fact specify different classes of members, and then they try modify their bylaws in a way that's inconsistent with the
Right.
articles of incorporation, you now have a mess to deal with. And Robert's rules would say, well, articles of incorporation take precedence over your bylaws, but it's still it's better if they're going to if they want to move their classes of membership from if they want them to be in the bylaws, then the bodies should also amend their articles of incorporation to take them out of there, or at least make sure it's very clear that they're not inconsistent with each other.
And other thing too with membership, and the law now it also authorizes dues, assessments, and fees. They can be authorized in the bylaws. The corporation can levy dues, assessment, and fees of the members to the extent authorized by the articles of incorporation or the bylaws. Dues don't have to be equal. They can be for different classes, different amounts and whatnot, right? Different classes may be exempt from dues, etc. You can also set a method for collecting them. You can also provide reasonable means such as termination or suspension of membership to enforce the collection of dues and fees. And so again, this just gives a little bit more meat to those provisions that can be like in your bylaws. Roberts already tells you that disciplinary things need to be sort of in your bylaws. This is just now a law that solidifies that.
I don't have anything to add.
Membership suspension and termination, that's added to the law. But here's a note, court challenges have to be filed within a year. And so it says membership in a corporation can be terminated or suspended for reasons in the bylaws, right? But a proceeding challenging the termination or suspension shall be commenced within 1 year of the effective date. And so that's a really good change because, sometimes organizations have really long-standing beefs. And so this at least puts a cap on when that challenge has to be filed if someone wants to sue over it. So I think that's a positive change that you're not going to have it hanging over your head forever. There's at least a finite endpoint to when they're going to do shut up or sue, put up or shut up, as they say, right?
But you do have to start that. You do have to terminate or suspend the member.
Yes.
If you just, it's not 1 year from when you started to investigate and start or
Mhm.
anything. It's when they actually were, when you as an organization or your client as an organization said, you're out.
This is a really, really big change. This is really big. So the law, starting in 2027, boards can now order an electronic election instead of having an annual meeting. It says a corporation shall hold a meeting of members annually at the time stated in the bylaws, unless one, directors are elected by written consent, which is permitted, or two, the board of directors authorizes the meeting to be conducted solely by ballot submitted electronically by mail or a combination of the two. So that is a big change. And so that, gives the boards a lot of discretion. There's other provisions in the law that allow you to sort of set um, pretty much like the authority of your boards and whatnot, like in the bylaws, right? And so again, this is just something that Jason talked about earlier, just making sure your documents like are consistent, right? If you want to completely prohibit the board from doing this, I mean that's sort of things that you need to address. Like more specifically in your bylaws now, right? Instead of the implied power of the board just to cancel the annual meeting and say we're just going to do electronic election instead of the annual meeting.
Yeah. I would be careful. This particular one, there's not a lot of meat on this particular one as far as I can tell. But
Hmm.
what if you if they authorize a ballot and you only get 5% of the ballots get returned? You know, you
Right.
much less than a quorum. Is that valid? I suspect a lot of this, and I wasn't part of the deliberations and discussions, but I suspect part of it is when you have a body that's having trouble getting a quorum, being able to actually affect getting a next round of leadership and doing some of the basics of just moving along until the organization is a bit healthier. So in some of those circumstances, it may be unlikely that there's going to be a challenge, but
Yeah,
yeah, I
it
wouldn't.
probably wouldn't impact really large statewide organizations, right? Because I mean, some groups have like 100,000 members, right? But they have different chapters throughout the state. They send their delegates to their conventions, right? And so it'd probably be impossible to get a quorum of 100,000 members. So groups like that are probably still going to have to keep doing their conventions, but
Yeah, I would just say if this is not something I would encourage
right.
a body to do, I wouldn't go, you know what, this annual meeting sure looks like a lot of work. Why don't you just authorize, well, let's just do everything by ballot. I wouldn't necessarily encourage that kind of thinking. And if you are in that situation, if, for example, the body was unable to get a quorum together and is just trying to get through the next year and invoke this, if I would ask them to get a lawyer involved as well,
Yes.
because you want
Just because you
this one
can,
has some
does it,
risk. I like the ratification one, very
Mhm.
clear. This is a little bit more we don't have to, you can't use it till 2027 anyway. But once you do, I just would say trade carefully.
Just because you can doesn't mean you should, right? And so yeah, that's really, really big change in that one.
That would be a good motto for the NAP.
Um, Next, pretty much if you have a meeting notice, if you have an electronic meeting, your notice has to include instructions on how to access the meeting, right? Roberts told you that anyway, but now it's really great that that's in the law right now. So that should increase fairness. Um, Next is about inspectors of election. And that's something to watch out for if you're ever dealing with a corporation client, because inspectors of election have different duties than what we call tellers under Roberts, right? Inspectors for election have a little bit more authority than tellers because inspectors can actually decide challenges and whatnot, right? Whereas tellers just count the votes and report the results. So that's something to keep in mind if you're ever asked to serve in that role. Make sure you say, well, am I just to verify I'm a teller, right? But pretty much the duties are simplified now. Inspectors, they just make a report of the results, right? And so they don't have to really do challenges or anything anymore, which I think is a good thing. So this actually brings them more in line with tellers under Roberts, to where they're just ascertaining the voting strength and the how many votes are cast for the proposals and making a count and a report of those results.
And
Uh,
that's and Donald, correct me if I'm wrong, but the appointment of inspectors is discretionary.
yeah, it's
Is
discretionary, so
okay,
yeah,
yeah.
you don't have to have them, but if you do, like this is
I mean, it's something, if you've got a contentious set of resolutions or elections or whatever, And there is the possibility of legal action because of claims that the tellers may in fact not provide an accurate count, then this is something to look into in more detail.
And then with any sort of review of elections, the courts will look at it. It's called de novo review. They pretty much look at it fresh from, the start, essentially. So they'll do their own, they won't give you any weight. They won't give your report any weight. Instead, they'll do their own de novo review. So keep that in mind.
Yeah. They're not bound. They'll
Yeah, they're not bound.
well,
Um,
they'd probably consider
they
it,
probably consider it, but the court's
but
gonna, yeah.
yeah, standard review is they'll look at the preponderance of evidence, and
Mhm.
your report is not evidence.
So this is a quirk. The definition of majority vote. So for corporations on the left-hand side, it the if a quorum exists on an action other than an election by the members, it's approved if the votes cast by the members favoring the action exceed the votes cast opposing the action, unless a great proportion is required by the chapter or bylaws, right? That's technically different than Roberts. Roberts, our definition of majority vote is approval has to be registered by more than half of the members voting on something.
Well,
Um,
voting.
yeah, so it's something to keep in mind, especially for things like there's a few things like appeals, right? Where technically it's like a majority in the negative overturns the chair's decision, right? Or like a roll call vote or filling the blanks where you're ascertaining like if you're filling the blanks, we're trying to get like a majority, right? But that might not be, votes in favor of an action exceeding those opposing, right? So it's little quirks in there. Again, I think something to watch out for. Just make sure if it's one of those weird quirks, is take a vote. Make sure you get getting a final vote on it, essentially, right? And or you might have to reword how you're putting the question, like the points of order and appeal, just to make sure that it's a majority in favor of the chair's action, not the majority negative opposing it, if that makes sense. Very, very strong, little nuance difference there.
Yeah. Well, it's creates potential
A mismatch for sure.
for confusion. Yeah,
Yep.
I mean, especially since if the bylaw, it does suggest you should have the rules of order adopted specifically by the bylaws rather than just adopted outside. That gives you some mechanism, although a lot of bodies don't like to specifically adopt. In fact, a lot of the public companies will specifically say, we're not bound by any rules of order for our meetings, because they don't want this body of rules that they have no control over to be used to take them to court. So um, yeah, I would say, yeah, the way that an appeal is done does create an issue there, and it may be worth having rephrasing it.
Yeah.
So, Robert says it's supposed to be, shall the ruling of the chair be sustained?
Hmm.
But if you do flip it around, shall the ruling of the chair be overruled? Then you get at least the right vote. But then all the parliamentarians are confused and upset.
Right. So keep that in mind. A few more things. Directors are elected by plurality unless the bylaws state otherwise. So that's just in the law. The directors it's plurality vote. So if it needs to be something else, make sure it's in the bylaws. The act also gives some basis for judicial reviews. It's not the only thing you can sue over, but basically it says these are the five main areas, right? So things like the result or validity of the election, the right of an individual to even hold the office, the validity of the vote, right of the director to membership on a committee, or the right of a person to nominate or be a candidate, etc. There's this, it lists out some basis there for judicial review of corporation elections, and also gives the court different remedies, which it's not an exhaustive list, but everything like the court could order new meetings or appoint a special master to conduct an election, right? Or give an injunction or other such relief. And so there's little things in there about it's also supposed to be done on an expedited basis. And so there's ever like an election like lawsuit, it's supposed to be done on an expedited basis, and there's different remedies that the law positively tells the judge can order. Another big change, ex officio directors can vote by default. So look at that very last sentence, unless the articles or the bylaws provide otherwise, an ex officio director shall be a voting director. So we know in Roberts, it just depends on how they're appointed and whatnot, right? Depends if they can vote or not vote or have the right to notice or count towards quorum. So that's something to keep in mind for your ex officio directors when looking at their bylaws, because now by default they are voting directors.
Need to give any indication of whether they are required to be counted for quorum?
Um, Probably yes, because the quorum is based off the voting directors. So I'd have to double check that though, but probably
Okay.
yes. Yeah. Um, Courts, they just reaffirm that courts can remove and bar people from election if they're engaged in fraud in the corporation. So, I mean, you could have sued over this beforehand, but putting it in the statute gives it a little bit more direction to like the courts. They don't have to like use their equity powers or anything. They're just implementing this, enforcing the statutory law. This one's really, really important. So the next two slides are very, very important. So they divide committees into two different types of committees. There are board committees and advisory committees. Board committees, under Roberts, we call them committees of full power, right? They are delegated authority to do certain things, right? So in a lot of corporations, it might be like an audit committee can approve the audit, or the personnel committee can hire and fire the CEO, right? And so if it's a board committee, if it's a committee that's exercising power of the board, only directors can pretty much vote on that committee, right? So non-board people can be appointed to the committee, but they can't vote on those sort of things. So if it's a board committee, only the board members can like vote on that committee. Whereas advisory committees just advise the board, right? They give the recommendations to the board, right? But anyone can be on those ones, but they don't have the authority to exercise any powers of the board. They don't have any other fiduciary duties. And so that's something, check through your corporate client. If they're a corporation, check through their bylaws. Is this a board committee or just an advisory committee? Because just depending on how it's established, depends on who can be on it, who actually can vote on it.
And that might be useful actually from insurance standpoint. You've
Yes.
got people, your directors, probably I haven't had to shop for insurance, but I suspect that the more directors you have with fiduciary duties, the higher the amount. If you have members, if you have advisors who don't have fiduciary responsibilities, then your insurance for your directors wouldn't necessarily go up as much, if at
Yes.
all.
One more slide for this one. Like I said, it was a big bill. Um, Corporations, they can enforce reasonable restrictions on the confidentiality, use, or distribution of records. And so, under the law, you have the right to request records like your meeting minutes and financials and things like that. Corporations can now say, you can't download it. You can only view it in our office, or you're not allowed to share it. Or if you do share it outside the membership, you can be removed or suspended from membership. So you can actually put restrictions and make it confidential. It's not, I'm going to get these financials and post it on my blog, right? Corporations are now allowed to, will be now allowed to put restrictions on those records that they give out. So keep in mind for that. So that was the last thing we had for corporations. Again, that was really, really, really long bill. We'll be talking about it for the next 2 years, I'm sure. But this is the preview you have now. Hasn't been signed into law yet, but it's most likely going to be by April 13th. And the last bill I'm going to talk about really, really quickly is about the small business program in Virginia. This is patroned by Delegate Yuan Ward, represents the Newport News, Norfolk area in the General Assembly. It passed, and it's awaiting governor's action. But essentially, this bill is going to mandate that micro businesses can receive preference for small purchases by state agencies. And so the goal for state agencies is to have 42% of the procurement dollars go to what they call it SWAM. So that's small women minority owned businesses, right? So small and micro, those don't have a demographic to it, but then there's women and minority owned. They do have a demographic, but they're all lumped together basically as a SWAM firm in Virginia. You can become certified, and under the law, purchases of 10,000 and below are set aside for micro businesses, and then between 10,000 200,000 go to small businesses. Now, again, if they can't find you pretty much can get preference in those procurements, and that's important because, like we talked about earlier, with some of these public bodies. And if they're a state agency and whatnot, right? Us, as parliamentarians, we have a leg up to compete for those sort of that business, right? I'll say, I mean, it's kind of rare that they post pure procurements for just parliamentary services. Um, I'll say from my personal experience, I've actually been able to successfully get a contract to do things like host webinars and whatnot for a state agency, and do meeting registrations. And so pretty much the work of a credentials committee I do for a state conference, and I get a cut of ticket, I get a cut of ticket sales. And so there are opportunities out there for small businesses if you know how to like look for them and whatnot. But as parliamentarians, I don't think many of us have engagements that exceed that $200,000 limit, right? But I encourage you to get your business small certified by the state so you can get those sort of preferences because sometimes when you do reach out or you kind of get wind of like, oh, the history commission wants like a workshop in parliamentary procedure, you can say, oh, well, I'm a SWAM business, right? And they're going to love you already because it's going to help them meet their procurement goals. And you can get preference and kind of get those transactions done pretty quickly. And so the size standard for a micro business is gross receipts fewer than $3 million dollars, and small businesses fewer than $10 million dollars. And so as long as your business is beneath that, you can qualify. And so I put that as a point out there.
And Donald, that is
Yes.
average. So if you had
Yes.
1 year where
Yes.
you got $5 million as a parliamentarian, but you didn't do so good the other 2 years, you're fine.
Yes.
Just make sure that nuance is out there.
Yes. So that's what we have. That was a little update that we had, but I'd love to take any questions now. And in fact, I'm going to stop the live streaming so you can feel free to talk without